And I think I have 7 minutes, do I?
Shock number. Yes.
Right. Thank you very much, Lascan Corla. And just to address some of the points made earlier in relation to just the combination of the two amendments that we've been discussing today, on the Article 41 reference change mooted by the community, that about the equality guarantee, the broadest equality guarantee, and as the Minister Gorman said earlier, there was, I was always concerned that was the wrong thing to do. You should never narrow down your equalities. You can't pick and choose your equalities, and the broadest possible equality guarantee seemed to me to be the most obvious and important thing to have, and remain exactly as it is. On the question of doubling down, the question of not removing women, and I'm glad to hear other speakers such as Breed Smith reference this, it's very, very important to say that this is not, the provision to remove women's duties in the home, and as Minister read it out, it's very important to, is not removing women from the Constitution, far from it. And in fact, of course, Article 45 still refers to men and women equally, but it does so in the concept of equality and referencing them as together and as equal, and not in the very outdated way that the state has currently references women about her life in the home, without which common good can't be achieved, and to ensure that she is not engaging in economic necessity to the neglect of her duties in the home. I could assure the Chair that I have neglected my duties in the home today, and probably every other day that I've been in the Dáil, and I'm not that bothered really about that. So I think it absolutely needs to come out of the Constitution. We were talking earlier about the question of durability and the evolution of the family form. I think it's really worth going back to think about this and how we've thought about families and evolving concepts in relation to it. In 2009, Dermot Ahern brought through the legislation on civil partnership and cohabitation, and it was an extraordinary piece of legislation in that it identified in an amalgamated way every piece of family law legislation, every piece of employment rights, every piece of succession, anything that you could possibly have where it related to an other, a spouse, brought it all together in one act and put in or civil partner, married or civil partner. And it did, in a most extraordinary way, exclude children entirely, as though neither partner might have a child. But that was the position taken because of the need to protect of the balance against marriage in the Constitution as it then was. So it was this active piece of work to ignore the existence of children from families who weren't married. Now, obviously, this referendum changes that very considerably. But then, of course, we had a big change to that in the Children and Family Relationships Act in 2015, which did the exact opposite. They took the same piece of legislation, the 2009 piece of legislation, and essentially put in children into that all the way through. And it fixed the 2009 problem, as it were. Thank you. It fixed the 2009 problem. And the argument at the time was, well, what changed? Because the underlying provision around the family in the Constitution didn't change. So what changed? And my argument at the time, which fortunately was successful, was that the 2012 amendment putting children into the Constitution was what changed. That you had children now who were express constitutional rights holders of their own. And because of that, they had to be conceived differently in terms of their rights to family life. Their rights were very different. And it was that argument that won at the time, which enabled us to get the civil partnership, the Children and Family Relationships Bill, through the Attorney General's office in time to enact it before the referendum, the marriage equality referendum, and very helpfully, and I can say now several years on, took the question of children out of that referendum and enabled us to pass it without distraction. The 2023 iteration of thinking about families, I think, is that further extension. If you go back and look back 20 years, we weren't having any of these conversations. We're now having a conversation where we not just recognise civil partnership, we recognise cohabitation, we recognise the rights of children as individual rights holders, we recognise them now as part of civil partnerships, then as part of married same-sex couples, we recognise that as a family form. We're now taking this extension further and actively placing on an equal basis children from families that are not married and treating those families in the same way. And we do need to account for it slightly differently in terms of the durability. And I think it really is worth thinking about that in a slightly different way, as a further extension, and perhaps not the end point, but a further extension at this time. And I speak directly to the care piece. And again, in the work of the committee, it started out, the interim report described care within the home or within the family and within the wider community. And as I said earlier, I always had a difficulty with this wider community concept because I couldn't place it constitutionally, how it could be linked, how it existed at all constitutionally, but how it could be placed specifically with that reference and not a whole lot of other references that weren't care-based references, that it wasn't something else. So my recollection is that the committee pulled back from that position and had a more it wasn't something that we pushed for in the end, because it was incapable of being defined. And my perspective on family care is not, it's one that's very much, or care generally, supporting care is a very strong political philosophy for me. Supporting care, I mean, I have been a family carer myself, the carer of a very, very sick child for a number of years. I remain alive to the changing circumstances that could have me required back to that full-time caring role. I was co-chair of the Families Carers Group before I became a minister, along with Deputy Pauline Tully, Marion Harkin, Niamh Smith. So my whole focus has been around care. So I've advocated for a massive extension in the eligibility of carers allowance with Heather Humphreys, which was delivered over 2 budgets. And again, I don't think that's where that stops. I think that is a progressive realisation of the value of care, the extension of the allowance, the extension of the pensions. This is all, as the Minister has used the words earlier, a progressive realisation of a concept that I think that we value, that shows our compassion and that is valued more broadly. But I really do think that there's something different about the professionalisation of care. And Deputy Batchik spoke to this earlier, that the unions weren't happy that the profession of caring wasn't recognised, or I'm paraphrasing slightly, but that the profession wasn't recognised. But I just don't think it works. The concept of family care, like when we look at carers allowance, we are talking about care within a family. We are talking about care within relationships. We're not talking about the professionalisation of that, and we can't have a read across to other forms of other professions, whether it's in Minister Rabbitt's brief or whether it's in Minister Foley's brief, teachers or other forms of therapists providing different types of cares. It's just different, and I think it is important that we have the family piece. But when I read the amendment itself, I actually take a much more expansive view. If I may, the state recognises that the provision of care by members of a family to one another by reason of the bonds that exist among them gives to society a support without which the common good can't be achieved, and shall strive to support that provision. Just 2 things. Sorry. Will you give me 1 minute? Will you give me 30 seconds?
1 minute would be very less.
Will you give me 30 seconds? 1, shall strive to is elsewhere in the Constitution. It's in the Directives of Social Principles of Policy, but it's not justiciable. This is a justiciable argument. This is a justiciable provision, and that is so different, and it enables that progressive realisation. But secondly, there is.
My colleague Jim O'Callaghan.